Hello and good evening, everyone, and welcome back to the lecture series of legal reasoning for the preparation of CLAT examination 2023. In this particular lecture series, we are dealing with the legal reasoning part of the syllabus of CLAT examination, which we have in our previous videos we have discussed about what exactly will be the syllabus that has to be learned for the from the on behalf of the CLAT aspirants, and what are the things that a CLAT aspirant is supposed to do and be consistent with in order to make sure that he is excelling with flying colors. We have started with the lecture series with the subject of Indian Contract at 1872, in which we have discussed about offer, acceptance, proposer, proposal, and what are the essential elements of a contract. And in the previous lecture series, we were discussing about the essential elements. We have talked about offer, acceptance, intention to create legal relationship. What exactly is the intention to create a legal relationship? We talked about the famous cases of Balfour versus Balfour and merit versus merit. Apart from that, we have discussed about the Stevenson case also. We have discussed Hadley versus Baxendale case and the various other cases which are of importance when it comes to the applicability of the principles in the Indian Contract Act and how that particular principles will be applied in the papers, in the questions that will be there in your CLAT examination. The only link has to be done in such a way that now, after understanding the topic, the candidate is expected, the CLAT aspirant is expected to start solving the previous year question papers and see through it that how many questions they are able to solve in a proper and a concise manner without taking much time. This will ensure that what are the loopholes that they are having, and obviously they will try to resolve out by consistently applying the principles in different situations. And once they are acquainted with how the principles are actually being applied in different scenarios, they will be able to answer the questions in a very easy and efficient manner. There has been lots of questions in regards to the intention to create legal relationship. You will have various problems on the case law of merit versus merit and Balfour versus Balfour. And apart from that, there will be many questions on what type of contract we are dealing with. So as we were discussing in our previous lecture, I suppose the screen is visible to you all. As discussed in our previous lecture, so basically when we're talking about the types of contract, when we talk about the types of contract can be divided into three major parts, one being void, second being valid, and the third being voidable. All these three types of contracts has been dealt under chapter 2 of the Indian Contract Act. We have discussed the valid portion of the contract. We have discussed the valid portion of the contract when we talked about what are the essential elements that have to be there if the contract needs to be enforceable. As you can see over the screen, it has been mentioned that essential elements of a valid contract. We have talked about what are the essential elements are there. We have talked about offer. We have talked about acceptance. We have talked about intentions. We have talked about consensus. Consensus means meeting of the same mind. And when we talk about meeting of the same mind in the same sense. Yes. So when we talk about meeting of the same mind in the same sense, what we assume is that there is a consent which is free from any external influence. Now, what exactly do we mean by this? We mean that when we talk about consensus ad idem, which means the meeting up of the mind, what we are assuring is that both the parties to the contract, whomsoever entering into the contract, are by their own will, without any external influence, without any external pressure, they are actually with their own will, with their willingness to enter into that agreement, uh, which can be enforced into the court of law and can be converted to a contract, is not being governed through any external sources. Now, when we say external sources, there can be a plethora of methods and way which by which any parties to the contract can be influenced to either to enter into a sort of contract. There has been various instances in the real life also. You might have seen different series, or you might have watched YouTube, where which you might have observed that somebody by decideful means has asked somebody to sign a piece of paper, and after their signature they were enforced, and in the end of the day the claimant or the person who signed that particular document was not even aware that he is the party to the particular contract. So that is why it becomes very important to make sure that the consent for all the obligations that is being mentioned under the agreement is free of nature and without any external influence. The Indian Contract Act 1872 in chapter 2 explains about what are a valid contract and what will be the essential elements. It also talks about what will be voidable contracts. Now, when we say voidable, what exactly, that there are two words which we can see here. One is being void and second being able. So if you see this particular word and you split it into two, the words that are actually making the meaning exactly is the same which is being depicted by dividing it into two parts. Any agreement which is valid, but can be considered voidable. The agreement is valid, but it can be considered void. Now, when we say can be, it can be considered void means that there should be some requisites, that there should be some elements that if they are present, if those elements are present in that particular agreement, then it means that it is not of free consent. So one has to see that if there is any sort of agreement and it is by its nature, it is being revealed that it is not with consent which is free in nature, that type of contract becomes voidable. And then starting from section 15 to section 22 of Indian Contract Act, you will find mention of those categories which will explain you that if these particular things are present, then that particular contract becomes voidable in nature. Voidable in nature means that although the contract is valid until unless any of the parties to the contract raise objection saying that their will was not taken from freely and there was no free consent and the consent was obtained through deceitful means or through external influence, then that particular agreement, maybe it may be valid before this objection was raised. But since when the objection was raised and post the objection, it can be proved that yes, actually the party has not been having the free consent, then the agreement can even be converted from a valid agreement to a void agreement, right? So what we need to understand is that what are these parameters that if they are present, a contract will be considered as voidable and not valid. So valid, if I try to differentiate between what is a valid contract and a voidable contract and what is a void contract, so the two major differences: valid means totally correct. So totally correct means 100% correct and it can be enforced in the court of law. Voidable contract means, voidable agreement means the contract is still valid. It doesn't mean that the contract has become void and it cannot be enforced in the court of law. It is still valid and can be enforced in the court of law until unless there is no objection raised over these particular parameters. But if the parameters has been questioned, that the will of the other party, the party who is the respondent, or if I may say, the party against whom the petition has been filed, if they can show, if they can prove to the court that their consent was not free and it was through external influence that consent was taken or derived, then that particular agreement is considered to be voidable at the instance of the party showing that their consent was not taken freely. So what are those grounds which are essential that CLAT aspirants should understand? Because how it will be there in your question paper is that there will be an unseen passage in which there will be a factual description of a problem, and they will be asking you that whether X party or Y party consent has been given freely or not. And by analyzing the case, and perhaps it is the most important portion of your syllabus in your contract, especially apart from the essential elements of a valid contract, that what are the grounds over which you can be if the candidate has made a contract and it is valid in nature, but still it can be considered as voidable, or agreement which can be converted to void, which has the ability to be converted void if these parameters are present, which has been enumerated under section 15 to section 22 of the Indian Contract Act 1872. And these elements are: the first element is coercion. Then the second one is undue influence. You can write these things down because I suppose that in the PPT you might not find mention of these names, but if you want to refer it, you can refer to section 15 to section 52, where with from section 15 you will find mention of coercion, and it goes to section 22 where you will find mention of the mistake. So now coercion, undue influence, then you have fraud. Then you have misrepresentation. And then you have mistake. Okay. So if these grounds are present, and we're obviously going to discuss these grounds to you, that what exactly is coercion, what exactly is undue influence, fraud, misrepresentation, mistake, etc. But once you get the thorough idea of what exactly do we understand by the terminology of coercion, what exactly do you understand by the terminology of undue influence, fraud, and misrepresentation, mistake, all these principles will be there in your question paper, and you will be asked that whether it amounts to coercion and whether the will of the parties who are entering into a contract is also free of nature or not. So first and the foremost thing that we will understand here is that what exactly is coercion. So when we talk about coercion, the thing that we need to understand is that coercion under section 15 has been defined as threats or force to influence the decision of the parties to the contract. You might have seen films where which a party has one villain has abducted the mother-in-law or the mother or the sister of the hero, the actor, and in that particular movie you would have seen that it was he was forced to sign the certain documents, and only after that the in-laws or the person who was confined was released. So telling this particular story will recall you that must have been some instances where which you would have observed that by the use of force, a person was asked to sign a piece of document, and his property was taken away from him, or maybe some other work was done. But in reality, when you come to reality, since it was a real life and it is a real life, you will find a difference here, because under the Indian Contract Act 1872, any threat or force in order to get the consent of the parties is not at all acceptable, and it is considered as voidable. Now I'll tell you, you might be having this confusion that's you're talking about voidability over threats. So why not it is considered to be void? Why not void? The reason for the same is that certain times coercions, undue influence, fraud, misrepresentations, and mistake, which are considered to be a ground for causing influence and hindering the free consent. So sometimes what happens is that whenever these two parties are there in the contract, they are unaware that there have been instances of force, coercion, fraud, misrepresentation, etc. So whenever these parties are entering into a contract, the person to whom these influence has been given, they have been given a right that if they feel that this particular contract is in their benefit and will obviously help them in their upliftment, or it is profitable for them, then they at their desire can continue with the particular obligations of that agreement, and it still will be considered as a valid agreement. So that is perhaps the reason because of these influences, whether it be threat, force, whether it be undue influence, whether it be fraud, misrepresentation, or mistake, any sort of agreement which is being signed will only be considered to be valid only after objection being raised by the person whose consent has been exploited or whose consent has been influenced, will be considered that he has the authority and he has the right to get that particular agreement void by proving to the court that these things, whether be it coercion, undue influence, fraud, misrepresentation, mistake, as mentioned in section 15 to section 22, if present, will hamper their free consent and has caused their consent to be taken without by influence, and that is why they does not wish to fulfill their obligation over that particular agreement, and the court will enforce that particular order in this manner, that they will not be obligated to fulfill the obligation that has been mentioned. But if at all there has been any transaction that has taken place by the other party, it is the duty of the person who is raising this particular issue that if at all any sort of transfer has taken place, they should return back that particular amount or anything that has been provided by the other party in order to restore their status before, in the same way that was before the and into the before entering into that particular agreement. So I suppose it is now a little bit clear to you that what exactly is a valid contract, what exactly is a voidable contract. Now, voidable contract specifically means that if these 5 grounds are present, it and the influence of the consent has been influenced by the external means of coercion, undue influence, mistake, and misrepresentation mistake, then obviously it at the desire of the person it can be converted to void. So just for your people's remembrance, I would like to tell you one short trick which you can utilize to remember these one, and that is CU, or you can just write it, can you find Miss Madhuri? Yes. So it is a mnemonic or just short story which you can remember in order to remember uh, all these external factors which is going to influence the free consent of the parties to the contract. And the free consent and the consent, as I told you, has been mentioned, and the consent has been mentioned under section 13, and free consent has been mentioned under section 14. Section 14. So consent definition section 13, and free consent definition section 14. Section 14 says that if we want to have a free consent, for essential valid contract, then these things shouldn't be present. But if these things are present, then the contract becomes voidable at the instance of the party to which influence was given. So means that the contract becomes voidable at the instance of the party to which influence was given, to the party at the instance of the party to which the influence was given, means the party who has whose free consent was curtailed can use this defense and avoid the obligations of the contract. And apart from that, after understanding what exactly is coercion, now I would like to shed some light over undue influence, and that is best understood by what exactly we have understood as a fiduciary relations. You will find this particular terminology in such a manner that whenever there is a fiduciary relationship, you must have recalled the case of Balfour versus Balfour. The case of Balfour versus Balfour, where there existed a fiduciary relation. A fiduciary relation is that relation which is a very close relation, like the relation of husband and wife, brother and sister, teacher and student, where which one party has the liberty by the because of their position in that particular relation, that they can influence the decision or the consent of the other party. I'll repeat it again for you for better understanding. That that one party is at that position that they can influence the decision of the other party. For example, if there has to be an agreement between a mother and a daughter, then the mother, because of being the mother of the other party, mother has much more privilege, and she can obviously influence the mind of the other party. So that is why these type of relations where which there exists a fiduciary relation, that type of relations have the authority to be converted into a voidable agreement if the other party to whom this particular influence has been given or taken has reasonable grounds to claim that his decision was curtailed and influenced by the relation that was existing between the party number one and the party number two. Obviously, the party number one being the mother and party number two being the daughter. So undue influence means that any influence because of the fiduciary relation that is existing, and at that point of time that particular agreement will be converted into will be considered as a voidable contract, and that particularly at the instance of the party to whom this undue influence has been administered. So after understanding undue influence, that it is much more of because of the capacity of one party to overrule the decision of the other party because of their command and their position in that particular relation. So that is why it is considered to be a voidable contract if undue influence has been proved in that particular matter. Then you have fraud. Fraud means providing anything in a deceitful manner by saying that this is something, and when we come to know that it is something different. You might have seen that there are various instances where which when we order something from Flipkart or Amazon, you get an entirely different product of what was expected from it. So what happens is that certain times there are frauds that takes place where which the people deceitfully changes the product and wishes to sell that product in order to get high margins. So whenever these type of instances are there, when fraud is being present in that particular transaction or the agreement that is taking place between two individuals, then that again becomes a voidable contract at the instance of the party against whom fraud was administered. I'll just like to tell you the definition that has been mentioned under section 17. Under section 17, which talks about fraud. So coercion has been talked about under 15, under influence under 16, and fraud under 17. So a contract is said to be induced by undue influence where the relations subsisting between the parties are such that one party is in position to dominate the will of the other and uses the position to obtain an unfair advantage over the other. I can give you an example here that has been also cited in your Bear Acts for a better understanding. And that example is that A having advanced money to his son B during his minority, upon B's coming to age, obtains by misuse of parental influence a bond from B for a greater amount than the sum due in respect of the advance. A employs undue influence. And when we talk about fraud means and induces any of the following acts committed by a party to a contract or which his connivance or by his agent with the intent to deceive the another party. With the intent to deceive the another party, thereto or his agent, or to induce him to enter into a contract. And the examples could be the suggestions as a fact of that which is not true by one who does not believe it to be true. Second is the active concealment of a fact by one having knowledge or belief of the fact. A promise made without any intimation of performing it. Without any intention of performing it. I have just promised that I will be doing something, but rather I have no intentions of performing that particular promise. Then it also considered as fraud. Any act fitted by deceive. If there is any scope of deceiving the other party, then also it is considered to be a fraudulent act. And an example can be B is A's daughter and has just come to age. Here the relation between the parties would make A's duty to tell B if the horse is okay. I'll just give you an example that A sells B by auction to B a horse which A knows to be of unsound mind. So now there is an example for you people to understand what exactly is fraud. So there is one person A who sells to B a horse which A knows that it is of unsound mind. Here, in this particular example, this is not considered as fraud. But in this example, it is not considered as fraud. I'll tell you the reason why. Because mere silence of description, the detailed description is not at all essential, but rather if they are hiding, if the person by whom the property is being sold, if they are hiding in order to make sure that that particular product is being sold without asking, and if they are being silent over that particular problem, that still the court has given the law has given this particular instance that still the case can be, the agreement can be enforceable. But if B would have asked A that whether the horse is of sound nature or not, and if at that point of time would have said that no, it is of sound nature, instead of telling that harsh reality, instead of providing the truth of that particular fact, then it will be considered as a fraudulent act. So mere silence cannot be considered as fraud. But if the question has been raised and that answer has been deceitful in nature, then that particular example, that is considered to be a fraud. And again, then there can be an example that if B is A's daughter and just come to age. Now let's take the example that B is the daughter of A. So now B is the daughter of A means that B is under the influence of A, because obviously she is the daughter. And if A knows that it is of unsound mind, and obviously since it is there is a relation that is existing between A and B, it is the duty to provide information about unsoundness of mind. So now if there is a relation that exists between A and B, which is of daughter and father, then it becomes a duty of the father to explain that that particular horse which she is taking is of unsound nature. Then only it will be considered as a valid contract. But if still the father knowingly doesn't disclose that it is of unsound mind, then at that point of time it will be considered as fraud. So I suppose the example, by this particular example, you have understood what exactly is fraud. So now let's talk about what is misrepresentation also, because misrepresentation and mistakes are the two things that has been left when you talk about having a free consent. And just remember that if all these things are present, it will only convert or change the agreement that has been there into a voidable agreement rather than a valid contract. The reason for the same is that since if these things would have not been present, the contract would have been considered as valid. So, but just because of the presence of these things, the contract has lost its value, and only if both the parties still wishes to continue with the terms of the agreement, then only it will be considered as valid. But if any of the parties raises at any point of time any objection, then it will not be considered as a valid contract, but will be considered as a voidable contract. So I would request you guys to kindly go through what exactly is misrepresentation and mistake, because these are very easy terms which you will find mentioned under section 18. Section 18 will talk about misrepresentation, and has been mistake has been talked about under section 20 to 22 of ICA. Yes. So now, when you talk about misrepresentation, the things that you need to understand is that the position assertion in a manner not warranted by the information of a person making it of that which is not true, though he believes it to be true. So here, when you talk about misrepresentation, so what the problem is that the one party is without any intention, because of wrong information, have presented the facts in such a manner that the other party misinterpreted it in a different manner, then that type of transaction is considered to be misrepresentation, and that particular transactions cannot be considered as a valid contract. It will be considered as a voidable contract. Voidable contract, if misrepresentation is present, it will be considered as a voidable contract, and so same goes with mistake also. So when you talk about free consent, these five things if not present, then only consent is free and contract is a valid contract. And if consent not free, meaning which presence of force, coercion, then these are identical. First is coercion, then second is undue influence. Then you have fraud. Then you have misrepresentation. And then obviously you have mistake. So if these things are present, then the contract will be considered as a voidable contract. Voidable contract means voidable at the instance of party whose decision, or I'll say consent, whose decision of consent has been through influence and there was no free consent. So if there is no free consent, then obviously if these things are present, it will not be considered as a free consent. If free consent is not present, we will consider it as a voidable contract. So now I suppose you are well aware that what exactly is voidable contract. Now let's talk about void contracts. Okay. So this is we were talking about part 2, and part 2 is an important portion of your CLAT examination when you talk about ICA, Indian Contract Act 1872. And we have talked about valid contracts. We have talked about voidable contracts now. And now let's fix our focus to void contracts. Now, when you talk about void contracts, what we assume is that these type of contracts are those contracts which are void ab initio. Which contracts are void ab initio. So now if we talk about invalid contracts, those contracts which are void is void. Void means void ab initio. And when we talk about void ab initio, what does this latent term means? So this latent term means void or unenforceable from the very beginning. So void ab initio means void from the very beginning. It means that there are certain acts which has been mentioned under the under the Indian Contract Act 1872, which talks about those acts which will be considered as void if these particular things are being present in that particular act. And I would like to mention here is that under section 26, under section 26, you have mentions of restraint of trade, restraint of marriage, I suppose. Yes, the section 26 talks about restraint of marriage. Section 27 talks about restraint of trade. And then you have section 28, which talks about restraint for legal proceedings. So all these terminologies, whether we talk about the restraint of marriage or the restraints of legal proceeding or restraint of trade, then all these particularly three criteria, any agreement if it has been made that A agrees that he will not marry B until unless there has been a certain act or there is a restraint of marriage between the parties, then that type of agreement is considered to be void ab initio, which means that it is void or it is unenforceable and it is illegal from the very beginning of the institution of that agreement. Now, second is becomes void. So there are also one more chance that when there is a contract or with whether there is an agreement, that particular agreement is valid, but because of the changes in the laws, that enforceability of that particular agreement is not at all possible. So now since the law has changed, that particular agreement becomes void. But it was not void ab initio because it was initially valid, but because of the change in circumstances and the change in the law, now that particular agreement cannot be enforced in the court of law, and that is why it is considered to be void. So I suppose you are now clear with the terminology of what exactly is void also, what is valid also, what is voidable also. And these particularly will assist you in understanding that, okay, if these particular things are present, then that particular agreement or contract is valid, void or voidable. And same will help you in assisting to differentiate that in this particular manner, if the contract is void, then the responsibilities or the obligations of the parties will not be there. And since the parties' obligation will not be there, then any of the parties is not subjected to work or perform any act, and that is why they will be relieved from all the obligations of their agreement. But if the agreement is a valid one, then every party, whomsoever is there, will be obligated to perform their duties. And if not, then there will be obviously compensation that can be entertained or carried out by the other parties. And apart from that, the contract also talks about one more thing, that if you have any contracts which is void in nature, as mentioned in section 26, 27 and 28, which talks about restraint of marriage, restraint of trade and restraint of legal proceeding. So if there is any agreement between two individuals for the restraint of trade, that you will not be practicing in my particular area, every agreement by which anyone is restricted from exercising a lawful position, trade or business of any kind is to that extent void. I'll give you an example for your better understanding, that there is an agreement in which a person is restrained from practicing law and just because there was an agreement that you can practice any profession but you cannot practice law. So these type of agreements where which there is a restraint of trade will be considered as a voidable, or sorry, as a void contract, and these are not as void agreements which are not considered to be a valid contract. Okay, and they are void ab initio. They are void from the very beginning. And then you have restraint for legal proceeding, that whenever there is an agreement, in that particular agreement, one party mentions that if there will be any conflict or any confusion, there will be no legal proceedings, or if the legal proceedings will be there, it will only be by the authorization of the party. Then that type of restraint is also not at all entertainable, and it will considered as void. Now we need to understand a very important differentiation between two things, because certainly you might be having a little bit of confusion in this, and I would be really willing to help you out with the same. And that is, what is the difference? What is the difference? So what exactly is the difference between void agreement and void contract? So when we talk about void agreements, those are those agreements which are void ab initio. So void ab initio means like these: the restraint of trade, restraint of marriage, restraint of legal proceeding. These are void agreements. Agreement in order to commit dacoity. These are void agreements which cannot be considered to be a valid one, and which is void from the very beginning. And then you have void contracts. So now void contracts are those contracts which have become void but were initially valid. For example, a contract which was voidable in nature, but after the objections were raised, it was considered to a void contract. Or another example could be that when the agreement was made and the contract was formed, that particular agreement had enforceability because law considered it to be legal. But then there was a change in the law, and because of the changing need of the society, obviously the law is a dynamic subject and it gets changed. So by implementation, by changing in the law, that particular agreement became unenforceable. So that agreement will also be considered as a void contract. So void agreement is something which is void ab initio. Any agreement which is not having lawful object or lawful consideration, that type of agreement is considered to be a void agreement. And void contract are those contracts which are not void from the very beginning, but they were considered as valid. But due to certain situations, circumstances, where, let's take the example of section 15 to 22, which talks about undue influence, coercion. If these things are present, and after the objection has been raised by the party against whom this atrocity has taken place, then it will be considered to be a void contract. I suppose now you have understood what exactly is the difference between void, valid, and voidable contracts. Now, there are other contracts also which I don't feel the need of explaining it to you, that what are illegal contracts. Illegal contracts are those contracts in which there is any talks of illegal activity. Then obviously illegal contracts are unenforceable in the court of law. Okay. If the contract is not fulfilled, is void. Agreement which is not valid from the beginning. Agreement which is not valid from the beginning becomes void. An agreement which is valid in the beginning, but due to some supervening impossibility, the contract becomes void. Now, voidable contracts, you know what I have told: an agreement forbidden by law, like robbery, dacoity, etc. Okay, agreement to do on. Now, unenforceable contract. What is unenforceable contracts? It is valid, but due to some technical defects. Now, there has been certain essential requisites in order to make a contract valid contract. make an agreement a valid contract. Now, there are certain impossibilities which cannot be removed, but there are certain situations in which if there is some technical issues, if that can be resolved, then it becomes a enforceable contract. So often this has been seen whenever there is an agreement and it needs to be stamped and the parties are unable to get it stamped, the court gives the direction to get it stamped so that it can be enforceable. Until unless the parties have not attached the stamp duty to it, it will still remain enforceable. So one has to make sure that if there is any essential things that has to be done in regards to ensure that there is enforceability of the agreements, then they have to go through each and every essential requisites of that particular agreement, and once after fulfilling all the important requisites, then only the contract can be understood to have been fulfilled and actions can be it can be enforced in the court of law. Now, what about different contracts are there? I suppose it is not important for you. Now, there is one more thing that I would be obviously discussing with you. And before that, I would just like to tell you one important thing, and that is, okay, yes, this is perhaps much more important for you, that when you talk about valid contracts, the valid contracts are also divided into certain criteria or differentiation has been there. Absolute contract, those contracts without any condition. So if any contract is without any condition, that if you want to purchase my watch, you have to do this particular act, or if you want to purchase my if you want to sell my pen, you have to do this particular act. If these type of conditions are not present, then that particular contract is considered to be an absolute contract, and this is perhaps the purest form of contract. Everybody should ensure that their contract is absolute, so that this becomes very much enforceable in the court of law, and if there is any dispute, that it can be also resolved very easily. Then you talk about contingent contracts. Contingent contracts are those contracts which are dependent over the happening or non-happening of a particular event, and that starts with section 31 and goes to section 36 of your Indian Contract Act 1872. I would just like to give you a definition for your better understanding, and that has been mentioned under section 31. When you talk about section 31, it says a contingent contract is a contract to do or not to do something if some event collateral to such contract does or does not happen. Collateral to that contract. What does that mean? That I'll give you an example, that A contracts to pay rupees 10,000 if B's house is burnt. So now there is a condition. There is a condition that has been mentioned in that particular agreement, that if your house is being burned, is burned, then I will pay you 10,000 rupees. So it will never be the liability of A to pay B 10,000 rupees until unless the house of B gets burned. So this is a perfect example of what we call as contingent contract, which is dependent on the happening or non-happening of a certain event. Now I give you an example again, that A makes a contract with B to buy B's house, B's horse. A makes a contract with B to buy B's horse. If A survives, okay, please understand, if A survives, then C. This contract cannot be enforced by law unless until C dies in A's lifetime. It means that a contract is dependent over a particular condition, that if during the lifetime of A, C dies, then the horse of B will belong to A. But if C doesn't die during the lifetime of A, then it becomes unenforceable, and that type of contract is also an example of contingent contract. And when you talk about an express contract, express contracts, this is nothing contracts which is described either in oral or in writing. So these type of contracts which are oral or writing are considered to be express contracts, where which one party is showing their willingness to do something or to abstain from doing something in order to get the willingness or consent of the other party. But when we talk about implied contract, express contract, we understood that it is something which is being written oral or writing. But when we talk about implied or quasi contract, what does that mean? It has been mentioned as section 68 to 72 of the Indian Contract Act, which talks about necessities provided to the person incapable of entering into an agreement. So I'll give you a small story for your better understanding. There was a miner of 10 years of age. He was at the platform, and there was a vendor who was selling samosas, and miner really wanted to eat those samosas, so he went there and he told him that I've been starving since 2 days. Kindly provide me one samosa. And without any hesitation as such, the vendor provided the child, the miner, with that samosa. And when he asked for the payment, he said that I don't have any money. So now, how that particular vendor will be compensated? Because when we talk about minors, obviously you cannot ask them to enter into any sort of contract. So in order to make sure that if any of the party or any of person is providing anything which is of necessity for the minor, and in doing so, they enter into a sort of an agreement with the minor to provide, or incapable of entering into a contract. Any person who is incapable of entering into a contract, whether be it minor or unsound minor, anybody, and in order to provide them with some necessities which is essential for their survival or for their growth or for their development, then that type of contract is still sustainable. But in this particular scenarios, in these type of actions, the contract is not with the minor, rather with the guardian of the minor. So if something has been provided to the minors or any person incapable of entering into a contract, and after that the obligation to perform the requisite task on the side of the minor shall be completed by their guardians, and it will ensure that both the parties' performance is done. So these type of cases where there is an implied contract between one party into the another because of the necessities that gets involved, these type of contracts are considered to be quasi contracts or the implied contracts. So implied contracts and quasi contracts are also important in regards to your question paper, because you might get questions in regards to the quasi contracts, where which there can be questions of claims of necessities applied to person incapable of entering, contracting, or on his account. An example can be A supplies B, a lunatic, with necessities suitable for his condition in life. A is entitled to be reimbursed from B's property. So the reimbursement will either be given from the guardian side, or if at all there is any sort of property that is being there for on the name of the minor or the person who is incapable of entering into a contract, then that person shall be compensated through that particular property. With this, with this, I would like to inform you that all the important principles that is in relation to the Indian Contract Act has been talked about. The legality of the object, I suppose you have already understood. The legality of the object means that the object should be lawful. No unlawful object can be entertained and can be possibly be executed as an agreement. as mentioned under the Indian Contract Act. And one more important thing, that possibility of performance is something that we just have to go through. And that when you talk about possibility of performance means that the act for which agreement is being made is possible. Now, for example, there is A and there is B. A wants to sell his car to B and B wants to purchase it. So they enter into an agreement. But while they were entering into a agreement, the car about which they were actually having communication was burned. So now the activities of A and B cannot be fulfilled because they cannot perform their obligation as the object has been burned. So possibility of performance is also very important requisite once you're talking about performing being a element of the valid contract. And writing and registration is something that has to be taken care of on the basis of the principles that you will be there. If your question that will be there in your CLAT examination talks about registration, that it will be specifically mentioned that the agreement needs to be stamped, the agreement need not to be stamped. So it will be written. So you need not worry about what exactly and how exactly the registration of the agreements has to be done. So with this, I would like to inform you that we have completed the law of contracts as the part of the legal reasoning chapter of legal reasoning subject of your CLAT examination. The portion of legal reasoning where which we are supposed to study six major subjects, along with one lecture over the case laws and the legal maxims. We have completed the first portion of that particular lecture series, that is Indian Contract Act. I would obviously be explaining you a lot of case laws in our last lecture series. When we were discussing the case laws, we will be subdividing the different case laws according to the different subjects that we will be studying. And after that, it will help you in revising the concepts also. And also you will have fresh mind when you will be going to prepare for your examination. Because as I have already told you that all these principles and the different guidelines that has been mentioned under the law books needs to be revised again and again and again, so that we ensure that these principles are there with us for a longer period of time. So again, I would request you to kindly go through with this video and try to solve out as many questions as possible, the multiple choice questions and other questions. And after that, after you have understood that how to apply these particular principles in the papers that will be available in front of you, it will be very easy for you to get the answers in the right directions, and eventually you will be able to qualify for that examination. With this, I would like to inform you that from next class onwards, we will be starting with the criminal law. We were supposed to start with the Indian Constitution Act, but because of certain technical issues, we are starting with the criminal law. That is also a very important portion, and you will be finding a lot of questions on cruelty, on murder, on different criminal acts that is present according to the Indian Penal Code of 1860. And we will also be talking about the procedures that has to be followed whenever there is a crime that is happening in our society, and what are the principles that one has to retain when they are trying to solve these type of questions. What is mens rea, as I've told you in the little magazine, what is actus reus, and how a person can be considered to be a criminal, and how the accused can be considered to be an innocent person. So all these things we will be studying from our upcoming lectures. And with this, I would be ending the video. I will be hoping that you will be going with your lecture series again. And if you face any queries or problems, I would recommend you to use the Bare Acts, because bare acts are perhaps the most genuine sources of all the laws. And if you will read it twice, thrice, or a number of times, you will be able to understand that what exactly law is talking about. Because I would like to quote here the saying of Swami Vivekanand, who has mentioned that law is nothing but it is sheer common sense. So in this way, I would like to tell you that once you have applied your common sense while reading the law, there is no need of going anywhere. Just stick to your preparation and stick to the bare acts that is present in front of you, and nobody can stop you from clearing your examination. Thank you so much, guys. You may have a good day, and we will be meeting in our next lecture, which will be comprising of the criminal laws. Thank you so much. Bye bye.